Hi, everyone. Thanks for coming to the Seattle Angel Conference Workshop Series. We do this on the meetup group Seattle-Angel. Our goal is to make the startup ecosystem go faster. One of the ways we work on that is helping startups get connected to the resources they need. The other way we do this is running angel conferences that help people who are accredited figure out that they're accredited and start writing their first angel checks. So our current program is the Transatlantic Angel Conference, which is coming to an end July 7th. And our Seattle Angel Conference 22 and Transatlantic number 2 are starting up again in the fall. And this workshop series, both Tuesday nights and Thursday noons, and in the meetup group has a wide range of topics that are going. Today, we're going to dive into the question around the legal perspective of naming your startup. I'm John Seacrest. I'm the managing director of Mossy Ventures, my umbrella organization to help drive startup ecosystems to being more effective by having stronger startups and more effective angel investors. If you want to be found by the other people on this call, feel free to put your LinkedIn into the chat. And if you have questions along the way, feel free to put them in the chat. I'll make sure that they get raised in the conversation if we're moving that way. In general, if you have startup access problems or things that you need to do, please feel free to drop me a note. John, glad to have you here. Thanks for coming. Why don't you introduce yourself and then just dive right into your talk?
Yeah, glad to be here. Thanks for letting me participate. And I'm going to call this more of a discussion, just to encourage people to jump in. We can go on side detours or zero in on anything I talk about at any time. But the overall topic is, yes, selecting a strong trademark, legal considerations for naming your startup. So a little bit more about me. I live in Seattle, been here for close to 10 years, moved here from New York where I started my practice in 2006. I've been focusing on trademark and copyright issues since I moved here in 2013, and I'm now a trademark attorney with Ryan Swanson & Cleveland, PLLC, Seattle-based law firm. I've had clients that really run the gamut, some Fortune 500 corporations, some presidential campaigns, global nonprofit organizations, but also a lot of startups, a lot of people in biotech, software, food and beverage, again, just sort of running a gamut. The trademark issues are pretty portable from one industry to the next. You may know patent attorneys can be very specialized in certain areas of technology, less so when it comes to the other intellectual property areas like trademark and copyright. The standards pretty much apply across the board, across industries. Last thing I'll say about me is I love what I do, and not all attorneys can say that, I'll say bluntly. So I like talking about it, and that's why I'm glad to be here. I'll find time just as a personal interest to talk about these issues with people who are curious about them. So I hope that no one is ever shy after this presentation to reach out. A couple of disclaimers right out of the top. Yeah, I'm an attorney. Yeah, this isn't a conversation with an attorney. It is not privileged. Attorney-client privilege kicks in at the point of reaching out to an attorney and describing the legal services you need, and then of course from the point of engagement forward as well. But anything we say here will not be confidential. In fact, as you know, it is being recorded. So just please bear in mind two things. It's not going to be confidential, and not to disclose anything here that you wouldn't want anyone with a YouTube access to find, and secondly, that my legal observations here will be general and not specific guidance or advice to anyone here. So with that aside, quickly on the agenda, I think you all got the blurb here. I'm just going to focus on the 3 bullet points at the bottom as an agenda. We're going to talk a bit about what a trademark is and also what it isn't from a legal standpoint. What makes a trademark strong or weak, again, looking at from a legal lens. And then third, just in the way of some scenarios, we'll walk through what clearance looks like from, again, a legal perspective. All of this being distinct from a marketing perspective. I think you've had presentations on that topic in the past, and it is, of course, very important. SEO and marketability and attractiveness of a brand are all very important, but also related but distinct from what it means to have a good legally trademark legally speaking. So we'll go ahead and dive in with the first of the items on the agenda, defining what a trademark is. Now, I just copy pasted this language directly from the USPTO. That's the United States Patent and Trademark Office. A trademark can be any word, phrase, symbol, design, or combination that identifies your goods and services. It is a source identifier. It means how the consumer knows that they are purchasing or acquiring the goods and services of your company versus a competitor's company. And you may have seen in the news, like the hot item of the week is that Ohio State University got a trademark registration for the word "the." I mean, it can be as basic as that. That could be a whole conversation that we could spend weeks talking about. But the point to stress here is that what a trademark can be is very broad and very vague. And in fact, even this description, I think, is incomplete, because the Trademark Office has also issued registrations for the color pink. The color pink in this case applied to adhesive tape, knowing that when you see pink tape, that you're getting that pink tape from a specific tape source, from a specific seller manufacturer. Or a storefront, an architectural design. Trademark registration, a trademark registration has issued for this design of a storefront. In the case of Disney, they've gotten, they're close to getting registration and have claimed trademark rights to this animation. Now, I'm not going to dive into too deep into the difference between a copyright and a trademark. Copyright applies to any sort of original content you create, and copyright goes hand in hand with the public domain. You may know that term. A copyright will exist for a period of time, and people then control their copyright during the term of the copyright, but then it enters the public domain, meaning that it's free for anyone to use without the permission of the owner. Now, a trademark can live forever for as long as you are using the trademark. So what Disney did in this case was decide, well, this animation still, we're going to start putting it at the front of our movies so that it functions as a trademark, and therefore we can layer those rights on top of the copyright to the animation. Hence, it becomes a trademark. It's that it can be that flexible a concept, to the point that the Trademark Office has issued a registration on a smell, the smell of mint applied to bowling balls. I'm not going to try to, spray you guys with the smell for demonstration's sake, so I just copied the text from the registration certificate. But that's really just to emphasize here that what a trademark can be is very flexible. At the same time, there are many things a trademark is not. We're going to go through these because this is important. This is going to be a critical point for this conversation. Whereas anything like "the" conceivably can be a trademark is not merely descriptive, or worse yet, generic. We're going to go through a little workshop example of how to distinguish between something being generic versus descriptive versus distinctive. Trademarks also are not non-distinctive ornamental design elements. That is a lengthy phrase. But you may think to yourself, well, wait a minute, we just saw the color pink. Isn't pink a simple design element? Again, the flexibility of trademarks means that, yes, it can be a trademark, but there's a distinction between something functioning as a trademark, as in pink on tape means you got it from the pink tape manufacturer, versus your website just happens to have a pink background. There's a nuance there that you have to have the right eyes and the right mind frame to make that distinction between the two. Or a third one, even slipperier concept, is a commonly used or merely informational phrase. The Trademark Office loves issuing refusals on that grounds these days. And you might think of it as, this isn't exactly precise, but the meme effect. Once something sort of reaches a social saturation, that you might describe it as a meme or a political slogan, a rallying cry, then it can cease to function as a trademark on a very basic level, so that, for example, if you take things from all across the spectrum, if you wanted to register the phrase "Black Lives Matter," many have tried, and the Trademark Office has taken a pretty consistent stand that, no, that's just become a commonly used phrase that no one person controls. It's belongs to the people, you could say. Stop the Steal would probably function on the same way, that if you tried to register Stop the Steal saying, I control the use of this phrase on t-shirts, the Trademark Office would probably say no. It's too commonly used to convey information, not to identify the source of your shirts. Now, the next few bullet points is where things might get counterintuitive. So again, an important point here I want to stress. A trademark is distinct from a trade name. So you decide what your LLC, your Inc., your sole proprietorship is going to be. And you may have certain legal requirements to do business in your state. You have to go to the Secretary of State, perhaps file for a business license, register as an LLC, or what have you. That's between you and the state, and it's a requirement at the state level to legally conduct business. But that's not consumer facing. So if you wanted to buy a product from so-and-so LLC, you might encounter them at the mall or on Amazon.com or wherever else. You're not going to the Secretary of State and looking them up there. So simply having a name that you find available for state business registration purposes as a trade name on your contracts, on your invoices, even on your business cards, that doesn't necessarily mean it's acting as a trademark. Likewise with a domain name. Now, day and age, you're going to have a domain name to do business, right? That's a threshold requirement for your business, almost certainly. But having a domain name, I compare it, not again imprecisely, to having a street address. It tells people where to find you on the web, but it doesn't necessarily mean you have any trademark rights to that name. It simply means that someone can type it in and find that you were the first person to register that domain name. And as long as no one else complains about the fact that you have that domain name, then it functions as a way to find you online, but it doesn't necessarily function as a trademark. Same thing with social media handles and the like. All these things that you want to have for your company once you land on the trademark that you want. But what you might hear sometimes, if you're in my shoes, is, oh, well, it's okay. I've secured the domain name, so the trademark must be available. Two completely different ideas. If a new top-level domain name is issued today, I'm assuming that like a .work or a .work from home is probably already exists. If not, it will soon. And I go register apple.work, and I just happen to be first in line to acquire it. Maybe I'm even using Apple in a way that supports my business somehow. Maybe I even call myself Apple. But that doesn't mean that I have rights that are superior to Apple, the computer company. It doesn't mean that I've acquired any trademark rights to the term Apple. It simply means that I was first in line to get that domain name. So now we've talked about the probably clear as mud definition of what a trademark is, what it can be, what it is not. Critical question for you guys now is, well, how do I select a trademark that is strong from a legal standpoint? First thing I want to talk about is availability from a legal standpoint. And what does that mean? Now, important point is trademark rights are jurisdictional. So the trademark rights that you might acquire in the United States don't necessarily transport over to Canada or EU or China. So we're going to talk about acquiring trademark rights in the United States, checking for availability. And the United States is a little different than most other countries, that it is centered on first to use. Now there's an asterisk next to that and a whole bunch of exceptions, as all things law. But basically, if you are the first to use your trademark and you find that no one else is using that brand for those goods and services, then you would have what we would call priority to that trademark. Now you might find though that the mark that you have in mind is in use by others. So there's a question of who might have priority there. It may not be you. You may not have priority to that trademark if you find that someone else is using it, has acquired a registration at the trademark office, or has some other argument that they were the first first in line ahead of you. But availability also considers likelihood of confusion, and that is the standard by which you would be judged for trademark infringement. If someone claims that you are infringing their trademark, they have to show that they were first in line, that they had priority over you, but also importantly, that there is a likelihood of confusion. So you'll see a theme here. I'm going to keep coming back to Apple because I find that it's an easy reference point for these sort of examples. If you find that the term Apple is available for your use in your special field, maybe you offer car insurance, travel benefits, whatever your particular service might be, and you make the determination that in that field, in that industry, no one has used Apple, so you adopt it as your trademark. You begin using it. You might file for registration, you might not. Now the question is, well, we know that Apple computers exists, so you're not the only person out there, but is there a likelihood of confusion? We would consider the brands side by side. And it's not as simple as, well, they're Apple computers and I'm Apple travel. First, the generic term on the end is not really going to help you. That's not going to draw a distinction between your brand and theirs. And then you decide, well, I'm going to spell Apple differently. I might use only one P or three Ps or something like that, or APPPEL. Well, you may be starting to form a little distance between you and them. Maybe the marks are not identical, but are they similar? Are they pronounced similarly? And then you have to ask, well, what are we doing versus what are they doing? That's the relatedness of the goods and services. And sure, they're a computer company, but do they also offer travel benefits through the Apple brand? It's not enough to say, well, we're not a direct competitor of theirs. You have to consider the breadth of what they do. You have to consider what customers they're targeting. You have to consider the channels of trade. And then lastly, also consider the relative strength of the common elements here. See, this is where things start to get real in the weeds and the nuance of the law really kicks in. Because simply having an available trademark and being the first one to use it doesn't necessarily mean that when you are comparing your mark against somebody else's, that there is confusion or that you have the rights to you have grounds to go after them for trademark infringement. The trademark office or the courts are going to question, well, how strong is your brand? The great thing about Apple, picking on them again, is that it's strong and distinctive for computers. It's not strong and distinctive for the restaurant industry, for food import or export, for dieting or wellness, for any number of other areas. So the strength of your trademark is tied to what it is you are doing and and how common that term is and what it means within the industry you are in. So let's talk about that. Let's really focus in on what makes a trademark distinctive. What makes it strong, not just simply available, but strong for your exclusive use. We talked about how just about anything can be a trademark, but at the same time, not everything is a trademark. Well, what does that really mean? Under law, the trademark office will apply a spectrum of distinctiveness in assessing whether or not something functions as a trademark and can provide you with strong trademark rights. Now I'm going to shift fruit here. I'm going to go from apples to cherries. First off, you have on one end of the spectrum a generic term. You want to sell cherry fruit under the brand cherry. Well, you're perfectly free to identify a product by its name. You can tell the world you sell cherries. You can get cherry.com if it's available. You can slap cherry on all your products. You are identifying in generic terms what it is you sell, not a trademark. Not a trademark. I don't care if you use it for 100 years. It's never going to be your trademark. Anyone else can, any of your competitors can also sell cherries using the term cherry. So you decide, well, I'm going to take the cherry flavor, I'm going to extract it out, and I'm going to start selling cherry candy. Cherry is not candy. Cherry is a fruit. There's a difference. It is not generic, strictly speaking, in that sense. But you go to a store and you're going to find 15 different cherry flavored candies, in half an aisle. Cherry Lifesavers, cherry gummy bears. Consumers are used to cherry being a descriptive flavor for a candy. Now, if instead of cherries, I selected Brussels sprouts, well, maybe the Brussels sprout candy line is unusual enough that you could build some trademark rights around it long enough that people, understand you're the Brussels sprout guy, and that's weird. So there's something there. There may be a brand there. But as a descriptive term, you're going to have a hard hill to climb to have any sort of exclusive rights to use a term, especially if you already know that your competitors are out there using the same term to describe their product. Now we hit the tipping point. You decide you're going to take the flavor and color extract of that candy, and you're going to go into cosmetics instead. Now, I don't wear a lot of lipstick, but I assume that the cherry color shade is probably common enough that you're not that far removed from the candy situation. That cherry lipstick probably will still be in that same sort of descriptiveness bucket. But I'm going to move the goalpost a little bit, and I'm going to change the spelling. Now you have cherry. I think when you look at that, there's only one way you're going to pronounce that is cherry. But you can at least argue for a couple of reasons that, well, cherry is a fruit. Cherry isn't lipstick, it's a fruit. It's suggestive of a shade of lipstick maybe, but I also misspelled it. So the consumer, when they look at this, has to use a little imagination. They have to say the word out loud and realize, oh, that's just like That's just like the fruit. The fruit is colored red. This is red lipstick. You know, if it were blue lipstick called cherry lipstick blue, then you might be in better shape because it's not as obviously descriptive. But you're kind of at that tipping point where you can start to argue, you know, with credibility, that is not simply descriptive, certainly not generic, and it requires some consumer imagination to get to your product. But you make a hard pivot now. You see where I'm going with this? Back to computers. And you say, well, no, actually, I like the brand. It was the product was the problem. I'm going to start selling computers. Now, you're in the arbitrary category because there's nothing cherry about a computer. It is arbitrarily applied to your product. It's a common generic term that has meaning that everyone knows. But in this case, you're applying it to a completely different type of product that now the consumer doesn't make any sort of association except the association of source. And that's what a good trademark does. It identifies source. Now, funny enough, you might run into a problem here. Apple might not be happy about that. They might think to themselves, well, we are the fruit computer. We've been at this for decades now. And when people think fruit plus computer, they think us. And this cherry is going to weaken the strength of that trademark. And we don't like what you're doing. And, you know, you have to decide if you've got a pocketbook that can stand up to the scrutiny of, you know, Apple and their 100 lawyers. Their argument to make, you know, and everyone's free to make their arguments. But at least from taking Apple out of the equation, cherry for laptop is arbitrary and the makings of a strong trademark. And now we're going to go off the cliff on the other side of the spectrum. If you want to guess what this one's going to be. I took the word cherry and I spelled it backwards. Now, you've been following me so far, so you know that when you look at that, you can, you know, your brain probably did it, you know, automatically saw that it was cherry spelled backwards. But remove everything else from the left of the screen, and the average consumer seeing however you pronounce it, has no association with that term. You have come up with a completely fanciful term that consumers will only think of as whatever you put in front of them. If it's the Urec, you know, travel services again, you know, if it's the toy company, then you have a lock solid trademark, provided that, going back to the previous slide, it's available. As long as someone else didn't beat you to that punch, that's probably wide open and clear for you to claim trademark rights to for any goods or services, and you're probably going to be in decent shape. Now, you may be in terrible shape from a marketing standpoint. I don't know how to pronounce that. But you know, with the right education of the consumer, like you have enough radio ads and television ads and web ads or whatever else, then they know how to pronounce it and they think of you and you're great. You know, you've done that additional legwork to imprint the brand on them. And that's a brand that, you know, is going to be a lot stronger than anything we talked about up until now. It requires that little extra effort that goes into the marketing piece, which I don't get into. I get into the legal piece. Legal piece, great, you're gold. Great trademark. So let's talk now about, you know, everything I've talked about so far barely skimmed on the registration point. I mean, maybe that's where your head was already at. Like, well, you have a trademark, you go to the trademark office, just like the is now a trademark because the trademark office said so. Not exactly, no, not really. All the trademark office did for Ohio State University was verify and put the government stamp on their trademark. Their trademark rights were based on their use, and what they argued was distinctive trademark use of the as a brand. They had to show examples that the appeared on the back of their t-shirts on the tag, not just on the shirt, but on the tag where you look for the manufacturer. And it's that use that in most cases for a US-based company is going to tell you when your trademark rights began and how strong they are. But registration does provide benefits. There's a reason people do go to the trademark office. Now, all that use that we talked about is geographic in nature. It can be limited. So, you know, back to our Apple travel company, if you are busy and active in Florida and everyone knows who you are, that doesn't necessarily help you in California or Washington, Alaska, Hawaii, Maine, wherever. It may not help you in Georgia even if you're not, you know, if you're not crossing the state line. But you get your registration at the trademark office, and the rights that they verify cover all 50 states. Now, suddenly you do have grounds to prevent someone from adopting your trademark in states you've never been before, whereas your solely use-based rights are going to be focused on where you're geographically active. It is the legal presumption of rights too, and that's a very important point. Everything we've been talking about so far when it comes to use is your argument to make. You ever get into a tussle with someone else, You send them the demand letter. You talk about all the years you've been in business, all the things you've done, the number of customers, the business, the numbers, all of that. You're building your case and making your argument. Nice thing about having a registration is that the trademark office makes the argument for you. You slap your registration certificate to your demand letter, and it's now on the other side's desk to dispute you. It's their burden, it's on their shoulders to argue that you don't have trademark rights. And the way you would typically do that is go to the trademark office and seek to cancel the registration, and that's a whole process. That's money out of their pocket. So the registration shifts that burden, and that's the main reason why you imagine most companies seek registration. Now, the use that we talked about is the TM. That is a signifier of common law rights, and it's not exclusive to that. You can have a registration and continue to use TM, but you can start using the TM symbol after your mark at any time. Once you start using your trademark and you're claiming it as a trademark, you can drop the TM on it. The circle R can only be used when you get a registration certificate for your mark for the goods and services you're offering. So very important never to use the circle R until you get your registration certificate, but the TM or the disclaimer language at the bottom that XYZ is the trademark of so-and-so LLC. You can start doing that at any time. It's good practice. It puts the public on notice. But just steer clear of the circle R unless you get the registration certificate. Now, there might actually be reasons why you don't want to seek registration. I'm going to give you an example here to highlight that. There is a coffee company who decided that they love the play on words espresso patronum. If you know anything about the Harry Potter franchise, that's a play off of expecto patronum or something like that from the third book in the series. I want to say the third movie in the franchise, spun for coffee, espresso instead of expecto patronum. They filed for registration, seeking those exclusive rights to use that phrase with the products of theirs, coffee. And if they put any thought into it at all, they may have thought to themselves, it's a different trademark. It's not the same as expecto patronum. It's for coffee. We're not selling books. We're not launching a movie franchise. We're not competing with Warner Brothers in any way whatsoever. So what's the problem? Well, the problem is that Warner Brothers didn't like that. They have challenged, they've signaled that they're going to oppose that application, which the public has the right to do. Your application goes through the trademark office. It gets published if they don't have any major objections that you can't resolve. And then the general public gets a window of time to oppose, and Warner Brothers has signaled that they intend to do so. Now, funny thing about it, though, is if you Google search espresso patronum, you'll see that it's actually a pretty common play on words. It's ubiquitous. There are dozens of mugs and T-shirts and stickers, and you might draw any number of conclusions. You have no idea. I don't know. Warner Brothers either doesn't know, doesn't care, didn't think they have the legal rights, or maybe just they don't have the budget to go play whack-a-mole trying to take down all of these products. But they weren't going to stand for someone claiming exclusive trademark rights to what is essentially just a derivation on their brand. And they went ahead then and also filed a bunch of applications to register expecto patronum for their own merchandise line. Now, this may be bad news for all those folks on Google, because now Warner Brothers has their eyes on this, and they're thinking, gosh, like a bunch of people are making money off of our brand. Why? Like, why aren't we the ones making money off that brand? So now they saw that this Cafe Creole stuck their head out when they could have been under the radar, when they could have just been a coffee company happily selling their products, playing off of the Harry Potter brand. No one's none the wiser. Now they're a target. Now Warner Brothers has their eyes on them. And my guess is between the two that Warner Brothers has the more sophisticated legal department. So registration, great idea, highly beneficial. Not always the way you want to go. I'm just going to go ahead. I'm doing a quick scan here of the chat. It looked like that may have been active. I hope everyone knows that they can at any time just cut and interrupt me if you have any questions or want to talk about anything in specific here. In fact, I have a questions slide right here to pause and take a break.
So there's one question I posted about these things being frivolous, right? we have the Evergreen State College, which is using the, and yet we have the conversation, or the whole bunch of things that taking that color, right? It's going to be really annoying when every color in the light spectrum gets branded. And so then, is there anything you can do about that when it's a little bit too generic to be that thing, right?
Yeah. So a few points on that. General point, there's no trademark police. There's no government office that actively goes out and enforces these rights. It is contingent on the rights owner to decide when and who against to enforce their rights. So what does that mean? Like, I guess everyone right now is going to have their eyes on the Ohio State University and see if they're going to flex muscles around their registration. And my guess is they'll be very selective about who they go after. And it would only be, other universities, other comparable institutions that poke the bear, right? Like, I don't think they're going to go start scouring through and picking fights just to send cease and desist letters to every college shirt that the word "the" appears on anywhere. But if the Evergreen State College starts putting "the" the in big bold letters on the tag, or get a little too cute or something playful with the as a brand, as specifically as a trademark,
it is a brand they use a lot, and you go look at their stuff, it says the Evergreen everywhere. Just so, I mean, that's a logical thing, right? Other people were using the before Ohio, and now does that mean the only way to solve it is to go to court and fight it?
Well, no, there's always going to be any number of solutions to that. One outcome here is that Ohio State University just sits on their rights, that they read the room, and it's not, for all the legal issues a university has to go through, this is not the fight they feel like picking. In which case, this was just sort of a fun story to tell. Like, oh, they got this registration, then they never did anything with it. Or they look for a test case and they say, okay, so maybe it's the Evergreen State College, maybe it's a letter to them to demand, and then it's a staring contest and it's a negotiation which may or may not be privy to the public, and we'll see who blinks. Maybe Evergreen decides, again, is this when we spend the next 2 years doing?
Your state attorney general, yeah, that would be fun. So then let's take that to the next level. We had a angel group that went and hired a marketing consultant and rebrand themselves, and became Element 8 Angels. And not very much longer, they were no longer Element 8, they were E8 Angels, because somebody complained around the use of the word element. And there are no other angel groups or venture capitalists using Element 8 as a thing. It was some other industry, right? So that seems really quite disruptive, right? So if they had decided to ignore whatever the letter that they got from the other people, what would have happened? Assuming that the other people were aggressive about their intent to maintain their rights for the word element.
Yeah, what you would expect, at least, this is the way the threats steer you towards, is that the other side with the rights, with the stake in this, will draft a complaint, pull them into court, and probably what they're going to end up looking for is an injunction. If they get a temporary restraining order, preliminary injunction, then that tends to be a pretty heavy leverage for the parties to settle. You might see, there'll be headlines from time to time about some major damages award, and under state law, you might even get some punitive damages that result in some crazy $1 million judgment. And those are real blue moon situations that tend to have some extenuating circumstances around them. Like, somebody was really, being reckless, or has very damaging evidence that they knew what they were doing and were intentionally trying to profit off of someone else's brand. So there's that threat hangs out in the air, though. that you might lose attorney's fees, that you might have to pay out of pocket in addition to lost profits, or just the sheer cost of rebranding. So that's always the sword hanging over people's heads. Courts are random number generators. This and copyright cases are just infamous for having wildly divergent outcomes without any clear way to predict how it's going to shake out. So
are the costs also random?
As in the attorney's fees, like the I mean, it's litigation. So I would say, just as a scale of things, getting good clearance and opinion on an available mark is going to be in like maybe in the low thousands. And duking it out at the trademark office, like you file an application and someone opposes your application, if you can't settle, settlement's probably going to be in the low 4 to 5 figures. Then you're talking about like 6 figures of costs to duke it out at the trademark office. It's like litigation light. It doesn't have as extensive discovery practice or motion practice as court, but it has a similar practice. But going to court, I mean, I'm not a litigant. It's not my bread and butter day to day, but I would tell just clients in general to assume that you got $1 million to spend. Like, are you looking at high 9 figures that you're prepared to go to the mats over this? Because discovery and motion practice is not fun. It's a long, slow, painful process. And the other side, depending on who has the deeper pocketbook, may have every incentive to spend you under the table, just make you hurt.
Mm-hmm. Okay. Do other folks have questions? Ken, Bharat, any questions?
I do.
Yeah, go ahead, Paul.
Good question. Creating the trademark for your company's name, basically to be protected from others who might take it futuristic wise. When would you want to do the trademark? Do you want to do it as soon as possible? Do you want to do it like later on when the company is established? What's the time frame there?
Yeah, great question. Not necessarily a one size fits all question. It's going to have to align with your budget as well, because every step in the process will likely generate some cost, or at least time out of your day. So on the one hand, I want to say a great rule of thumb is establish your trademark as soon as possible. Going back to that priority point, your great idea might get taken by somebody else, tomorrow or in a week or so, right? And then you may be just out of luck. That priority point might just kill you dead in the water. But that's not always realistic. Of course, that can't be where you put your time and energy. And here's a way to think about it. One of those asterisk exceptions to priority first to use point is that you can get an application on file at the trademark office based on intent to use. Now, they're not going to issue the registration until you later confirm that the mark is in actual use, like you're actually providing the services, you're actually selling the goods across state lines, in particular for federal rights. So, Washington to Oregon is fine, but it has to go across the state line. But you can file, you could file today, and the process at the trademark office will probably take at least a year before if that application is getting through. And then, if it's smooth sailing and it's as fast as we can realistically expect it to move these days, then you might get to the point of allowance. Now, from allowance, you're given basically 3 years with some extension fees to confirm that the mark is in use before that application will lapse. So on a timeline of things, if you know that whatever it is you're going to do with that trademark, you're going to do within the next, let's say 3 to 4 years, and you don't mind some processing costs, some administrative fees along the way, a few $100 here, a few $100 there, then, dollars to donuts, your best bet is to get that application on file today. Be prepared, though, that you may not know the outcome of that whole process for some time to come. So, if you're spending a few $100 now to get an application on file, and you're prepared to just, write that off if it doesn't work out and you have to shift gears, well, then the benefit you get is that your rights will always tack back to today. Then anything that happens after today is junior and you're the senior. But if you want to have more solid ground to stand on, then you want to budget in some time and money to clear. And that's actually going to be the last section here is, what does that clearance process look like, and how do you get to the point of comfort that you're not just throwing money down a well?
And the thing is, if I apply, for that want, I guess, to have a trademark right now, so I have like actual an evidence that I've done something about it. So previously, and then someone else is taking it over, has a bigger wallet, so to say, than he's taking the trademark. Here you have a proof, at least, right? Would that be the case, or?
If I'm following you, there's two factors there. If you have some activity under the trademark and it's public facing, it's not just you talking to vendors or partners or under NDAs or things like that, but you've actually done something with it, that goes outside the company to customers, then your rights could go back to when you first started doing that.
Okay.
And that's evidence. You'd have to show that, if you got into a tussle over it, you might actually have to produce documents to show that. Getting something on file at the trademark office, though, is public record. So the world will know that today you filed to register that mark for those goods and services, and that'll be a fixed date.
Got it. Thank you, John. I appreciate it.
Any other questions? John, go ahead.
I just talked to somebody last night, and they'd actually just trademarked their company just in Washington versus how does that work?
Yeah, great question too. So every state, I believe, does have its own trademark office or equivalent where you can file to register as a state trademark. Sometimes different languages used, but it kind of amounts to the same. It is an option. It can be fairly inexpensive. I think sometimes the fees are as low as, below $100 just to get it on file. And that's you're just paying the processing fee. And the review process at the state level, I don't think is particularly rigorous. So, you might be able to get it and then you have it in your hand, and then what is it worth exactly? Well, it's a public record. It is a reference point that, oh, well, I've been using the trademark for so long, and here's the filing receipt for my state trademark to support that. It doesn't provide the same power as federal registration. And I would, at the end of the day, rather have, if I had to choose, concrete evidence of actual use rather than a Washington State trademark registration certificate. It's not to say, like, I can't say that I've actually seen it play out in court, so I'm not going to say that it is not worth pursuing. And for the low cost that you get it, sometimes it's sort of a, well, why not, right? Like if I can add to the evidence of my use and rights, why wouldn't I for $50 or whatever, right? Whatever it costs. But it is in no way equivalent to a federal registration. Well, guys, I'll go ahead and then jump to the scenarios to talk through what that clearance process looks like. And I think using some real life examples will really flesh out what some of these points I've been talking about look like in practice. So just for clearing a trademark and understanding the risks. Clearance, rarely is going to give you a firm black or white answer as to whether or not a trademark is available and registrable and all of those things. There's 99 times out of 100, it's going to be in some area of gray. And if you're doing it from your desktop or just seeking the what you might call a knockout quick and dirty search from a trademark attorney, what you're going to get is that tip of the iceberg, the things that you can find online. TESS is the public database of the trademark office, the USPTO. So you can, you're free to search that using basic Boolean search terms. We mentioned state trademark offices, well-timed question, because state trademark offices can also just be a useful publicly available database of information if you know where to look, just to try to spot who else is out there. Obviously you're going to search Google or Bing or Yahoo or whatever, and you're going to be, you'll get the results the algorithm wants you to get. So, there's a certain surface level of results you're going to get through that process. When we talk about a legal clearance search, what you might heard call a full search is a deeper dive, as the picture illustrates, where you're looking at business records. If you're using a vendor who has certain algorithms or certain proprietary search tools of their own, they may be looking at state-by-state business filings. They may look at domain names that have been registered but not yet put to use, and all of that can be the smoke that helps you to pinpoint business activity that wouldn't necessarily be evident from a simple Google search. So you're really just trying to dig deep and see if you can identify that sort of early or off the radar business activity that won't be obvious out of the gate, but may bite you in the butt if they come out of the woodwork 6 months or a year into your business launch. Tell you what, we talked through all of these points, so unless anyone wants to revisit any of the concepts of priority, first in time, or what likelihood of confusion means, we'll go ahead and dive into the examples. All right, so nothing that I worked on here. I just pulled these out of internet research. You had a mark for Pro Blue, and they offer some sort of security services, computer security services. They filed for registration, and they got blocked at the trademark office. The trademark office examiner looked at that filing against previous filings, and they found Blue Pro, and the trademark office refused Pro Blue based on Blue Pro. Blue Pro offers, according to their registration, a whole suite of computer software services, and buried within them is the language that I plucked out and that the trademark office focused on, which is concerning security, checking for viruses, security threats, internet connection tests, and other computer troubleshooting. Now, you might see what happened here. Pro Blue, maybe they did a simple word search and they didn't find anybody had filed to register Pro Blue. If they saw Blue Pro, they might have thought to themselves, well, they're not identical at all. Blue Pro and Pro Blue are completely different, aren't they? In fact, we use the French spelling of blue, and that's the English spelling of blue, and it's a logo, and our logo doesn't look anything like their logo. That all may be true. It may also be true that these guys may not be competitors. In the real world, who knows? I don't know if Pro Blue had actually been operating for months or years or who knows how long without Blue Pro ever raising an issue. So in the real world, they may happily coexist and none the wiser. But at the trademark office, what they're going to say is, or what they did say was, these are functionally identical. And that may be funny to hear, but it's true from the trademark office's standpoint. Because transposed terms, flipping them around, doesn't get you very far, not from a trademark likelihood of confusion perspective. So just, you're not going to have any luck arguing that point with the trademark office in most cases. You transpose the terms, that's not enough. We're Navy old, they're Old Navy, forget it. It's not going to fly. The translation point that blue is French or the French spelling and blue is the English spelling runs into the foreign equivalence doctrine. And from the trademark office's standpoint, unless you're talking about a very rare language that few Americans know of, which is not French, French is well spoken in America relatively for foreign languages, then the direct foreign translation of a term will be treated as the English equivalent for this analysis. So it doesn't help you at all. And you're certainly not helped by the fact that blue and blue, I'm sure I'm mangling that, but are essentially phonetically the same. So just saying it out loud, you can say, well, these are basically the same term and consumers will think so. The fact that Blue Pro offers a wider scope of services is also not at all helpful. All it requires is some overlap of services or some relatedness of services. They don't have to be identical. You don't have to be competitors in the real world. The trademark office, looking at these filings side by side, probably had an easy decision on their hands. They said, nope, there's likelihood of confusion here. We're not going to issue your registration. Remember what I talked about with Espresso Patronum, right? Pro Blue had a decision to make. They decided to seek registration. They probably had good reason to do so. They wanted exclusive rights to their brand. They were excited about it. But there's no reason from the trademark office's standpoint, from a simple legal reading of things, that they couldn't have just launched Pro Blue and taken their chances. See if Blue Pro raises an issue, and then you play the waiting game. Who knows? And even now, Pro Blue may continue to operate. I didn't do any research there. They could very well still be operating under that name. It's on Blue Pro. Again, there being no trademark police here. It's on Blue Pro's shoulders to decide that they're going to send Pro Blue a demand letter. They may or may not even be aware of the whole situation. Now, a trademark attorney will offer that as a service to monitor for these things. But it's entirely possible that Blue Pro didn't even realize that this whole drama was taking place. And then they have to decide, well, are we going to send these guys a demand letter? What are we going to do? And if they decide to send them a demand letter, well, they have a very helpful public record at the trademark office that the government issued a decision saying that there's likelihood of confusion. That doesn't mean that that's not an injunction. That doesn't mean that Pro Blue has to stop doing what they're doing, but you don't want to be in their shoes. And that may have been a conclusion an attorney or someone inside could have told them beforehand that, hey, if we're likely to get a refusal, and that's likely to be this public-facing record that shows that we don't have a strong trademark claim here, maybe we don't want to seek registration, or maybe we want to reconsider our brand. Now, this is all Monday morning quarterback, right? It's very easy for me to make all of those assessments now, but that's what Pro Blue could have been thinking about when they've decided to register, hopefully at least aware of the fact that Blue Pro exists. And again, here we talked about the distinctiveness points. I won't go revisit the high level points. We'll get into some examples. Distinctiveness objections can seriously run the gamut, and the trademark office is not limited to the types of refusals they can issue in this category. But here's a few that you want to think about and keep in mind. One is the simple merely descriptiveness refusal. In this case, it was archive. And one of their services was paper document storage. Now, where do you store paper documents? You store them in an archive. Except that they thought, well, we use archive misspelled as a sort of portmanteau or whatever with ark, like Ark of the Covenant, like Noah's Ark. We're trying to play off of consumers' imagination here and be more than just an archive. We're like a holy sanctum for your documents. I don't know, whatever their marketing team came up with. And the trademark office refused that. They said, "Look, it's a novel spelling. We'll give you that, but it's the phonetically equivalent. It is a highly descriptive term for what you're doing. It's not enough to change a letter in the term. And you've come up with some creative arguments as to what archive is supposed to mean, but trademark office took one look at that and just, no. Sorry, that's a bad leap I'm making there, but it's the best I could do." This applicant's face melted off because in staring down the examiner, they lost. So a few things, just some high level takeaways here. When you're thinking about your trademark, it's a gut check time. At its root, like maybe we're playing around with the word, maybe we're trying misspellings, maybe we're combining it with other terms, but saying it out loud, does it describe what we do? Is our misspelling, is our playing with the word enough? I mean, enough is in quotes. It's a very mushy term, but is it enough that we can plausibly argue to the trademark office that the word we are using as we expect people to say it out loud doesn't simply mean or identify what it is we're doing? And are your competitors using the same term? Again, it's just one of those gut check sort of things, that basic term, that archive term. If your competitors are using the same term, then that's sort of a warning sign, because the examiner will probably find that as well and throw that in your face. Now, the good news, I guess, at the end of the day for these guys is they're free to use it. It is in that sense available. It's simply not distinctive enough for them to use it exclusively. Likewise, with our friends over at the East Coast. Now, in this case, it's a primarily geographic issue. Same basic bucket of categories. It lacks distinctiveness, but a company that provides vehicle towing services filed to register East Coast. Now, the particularity of a geographic refusal, primarily geographically descriptive refusal, is that the term in question is recognized to identify a specific place. It doesn't have to be a city or a town or, a state even. It can be the entirety of the East Coast of America, but it is a known geographic location. You're not talking about the East Coast of Lake Union or China. You say East Coast in America, people know what you're talking about. And the other point is that region known for the goods and services? Now, I think the trademark office got a little blurry here because I don't think of the East Coast as the home of vehicle towing services, the way that Washington is the home of apples and Florida oranges and Idaho potatoes and so on and so forth. But the trademark office, this was still a bridge too far for them. They thought, no, look, the East Coast has cities up and down. Towing services are all over the place. They come from the East Coast. People draw that connection. Other companies should be allowed to describe themselves as an East Coast towing company. So we're going to refuse this on the geographic refusal grounds. Again, high-level takeaway points here. What can make a mark attractive because it helps people find you and identify you can also cut against you when it comes to building a distinctive trademark. Are you using that term because you want people to know you're from that region? And do you like that term because the goods and services you offer are known to come from that region? Well, those are signs of a geographically descriptive refusal. Or, same time, flip it around. Let's say you're calling yourself the East Coast Towing Service and you're based in California. Well, now you're misdescriptive. You've taken the same concept, but now you're trying to trick customers, the trademark office would say. So you don't get around it by using something that is actually factually inaccurate. That's not an argument. That's just a separate kind of refusal from the same quiver. Okay, one more here. This is the dreaded failure to function refusal. You ask me, this is my boogeyman. The trademark office loves to pull this out these days. It's an easy way for the trademark office with very little heavy lifting on their part to say, we're just not going to register this because we don't think you should own this trademark. And in this case, the guy I'm picking on is a film company. I think that they, make a schlock, Z grade. We filmed this over the weekend films, and they release it under the brand Worst Movie Ever for films. And the trademark office found it to be a commonplace slogan used by a variety of sources that merely conveys an ordinary, familiar, or well-recognized concept or sentiment. I mean, all of these are very mushy terms. It's very easy for the trademark office to conclude based on a 5-minute Google search that the phrasing "worst blank ever" is just too memed. It is too ubiquitous. It belongs to the people. I mean, blame The Simpsons, I guess. Ever since Comic Book Guy called one episode the worst episode ever, it just caught fire. And I have no way to tell you how to gauge at what point something goes from being, a fun, catchy saying that is attractive as a trademark, perhaps, to a quote unquote commonplace slogan that no one can own. There's some blurry point in time that it went from being potentially a distinctive trademark because it's not generic, right? It doesn't identify the product. I mean, you could say it's descriptive, I guess, although in this case, worst movie ever is clearly they're having fun with it. And may have been, available in that no one else is using it as a trademark. Only you are the one using that phrase as a trademark. But if, going back to our high level takeaways, if you can find that the mark you have in mind, the slogan, the word, the phrase, the image, whatever it is, all over t-shirts, all over blogs, all over tweets, all over being a legal term here, I guess. If you find it all over, then you might have drifted over into the failure to function territory, where, I rarely see trademark applications survive that refusal. And why I call it the boogeyman is that generic is one thing. It's easy to flag something generic for somebody. You want to sell cherries? Well, don't call your brand Cherry. Very simple. But you want to sell Cherry computers? Hey, go at it. It's arbitrary. But if the trademark office decides that cherry, or boy, that's cherry, or something like that, is a commonplace phrase, then you're not going to get it registered for anything. That's what makes it the trademark killer. Anyway, okay, so we walked through. I want to check. See, I'm not sure how long I've been going at here. I think I've actually run over time.
We're fine. We have time for discussion.
Yeah.
I think I'd like you to spend a little bit of time on essentially the notion of freedom to operate, right?
Yeah.
So I start a company, I'm doing my thing. some random idiot from some other place in the world with a lot of money decides that I'm stepping in their space because they figured out that I exist. And now I have to rebrand because they did some paperwork and I didn't, right? And so talk about what's sort of the minimum protective behavior that a startup should be using so that when they finally go IPO or get on the, radar at the national level, that they don't end up having to redesign a whole bunch of stuff on the fly.
Yeah. So I'm going to slide back to this image because I think it can be helpful for us here. Like the bare minimum is that tip of the iceberg category, and I think that's a fairly decent ranking. Now, freedom to operate. If you see that someone has registered a trademark, if you've identified not just identical, again, like think about these guys, right? These weren't identical, but if you can using appropriate search terms to ferret out where the similarity might be. Somebody's gone through the steps of registration, has at least enough budget to get a registration, right? Has at least enough interest behind protecting their brand to have taken those steps, and they've got the receipts, and you may be running up against a brick wall. So I would say that bare minimum, although registration is optional and is not the full story by any means, that's an easy first place to look as a starting point to make sure that you're not going to step directly on someone's toes who may have the pocketbook to come after you. State trademark offices can be difficult to search, but if there are states where you are operating, are going to be critical to your business, where you are based, worth also just scanning that, hunting down and scanning that state trademark office database. And yes, you do have to do at least, I think, some internet searching. It's hard to provide concrete guidance around desktop Google, desktop Bing searches or whatnot, because you're at the whims of their algorithm. And I think there's some study that says 90% of people don't look past the first page of results, and I'm making up that number, but you know what I mean? Like there's a huge drop off, and after page 2 or 3, basically you're in a desert. But that doesn't mean that those people don't have rights, and it doesn't mean that they can't bite you if they discover you. So I would take that internet search, you're searching Facebook for accounts, searching Twitter for accounts, with a giant grain of salt. Yes, important, useful to do, because obviously if they're on that first page, that's a red flag that you need to be careful about that, and look pretty seriously at them. But that's that sort of bare minimum level. And clearance searching through someone with who's active enough, who's sophisticated in trademark searching, that can be worth the spend for that deeper dive, even if you don't plan on seeking registration, even if you're just looking for freedom to operate. John, you're on mute. Wasn't sure if you were talking to us.
The evil mute button. So the fact that I did the search doesn't leave a digital footprint anywhere. And so I have to do something somewhere that leaves a digital footprint, right? When I'm doing a patent search and I do a defensive patent, I at least file a provisional patent so that it's in the database so that people find it when they search that I've been here before. What's the equivalent low level of putting a spike in the sand to say, I'm here and this is mine? Putting a paren TM on it, is that enough?
Yeah, it's an interesting point, because like patents and trademark offices, patents and trademarks, despite being in the same office, can really operate under different rules. And the two surest ways to establish your first in time is, file for your intent to use application to register, understanding all the risks that come with that, the espresso patronum situation, or launching, moving forward with your business.
But I have to do the paren TM thing somewhere, don't I?
It's not necessary, but it is good practice, because it clearly designates what you claim to be your trademark. And, the average website, there probably won't be any doubt about it. It should be, whatever your design team tells you. Top right, high or top left, bold, visible, only use all caps, whatever the sort of like design tips you get. It's bright, sparkly, flashing letters, something that grabs the attention. But the nice thing about the TM, yeah, it puts the public on notice. I don't really know how much that gets you, but it's clear. And having a sentence at the bottom of your materials, your website, your pitch, your brochure that says this and that and the other are the trademarks of. Avoid doubt. And there's branding schemes or just design schemes that are sort of like, like the TGIF style, if that's a reference, it's just like a cluster, it's just a million images that are all over the place. And if that's, that could be a fun, attractive branding style, but it doesn't tell you what they're actually claiming as their brand. So, clarity and consistency are your friends from a legal standpoint.
Cool. Yeah, Paul.
I had a question about what if there are multiple, because I've seen multiple registered trademarks with the same name.
Mm-hmm.
What's the situation there?
Yeah, great question. So the likelihood of confusion analysis kicks in. That's where one of a few things could be happening. First, if you haven't dug in to see if they're all owned by the same party, they may all be owned by the same party, and they've just filed to register the same brand or slight variations for a range of services. If we look at these guys on the right, the Expecto Patronum, that Warner Brothers just filed whatever that is, 8 different applications covering 8 different categories of goods. So that's just a filing approach. They could have filed one application with everything included under one, or they could have filed 8 with 8 different categories. It's it's kind of a 6 of one, half dozen of the other. Or you have a situation like the one I always use is Lexus, because Lexus is a car company and they would file for car parts, cars, car, servicing, car insurance, whatever. And there is Lexus, the legal research provider, which is a website you go to in law school, and some people continue afterwards, where they use it to search for case law and statutes. And no one's going to be confused about which is which, even though the marks are identical or nearly identical. So it's entirely possible for I was getting played off stage there. It can be entirely possible for many people to coexist, because you're selling widgets and they're selling wadgets. That's not a word, but never the twain shall meet.
Okay, I got it. Makes sense.
Now, where you can run into, like, I want to put a big warning sign underneath that, because between the internet and conglomerations, it is very easy for a Warner Brothers, for a Disney, for I don't know, Elon Musk or whoever, to say, well, yeah, I mean, Tesla's a car company, but you could say 2 things. One, it's famous, and famous is actually a legal category of trademarks where you're not going to get away with your Disney branded such and such just because Disney doesn't happen to offer those products. It is a famous brand and everyone knows the Disney brand, and it transcends its category. You'll never get a registration for Disney unless you are Disney, whatever it is you're doing. The other thing that can happen is they can argue, well, yeah, I'm Tesla and everyone knows who I am. And yeah, I don't sell, what are they called? Cup holders, what is like foam cup holder containers. I don't happen to sell those, but everyone knows the Tesla brand, and it's natural that a car company might sell those because you buy a drink and then you put it in your car. So I have a zone of expansion, and therefore I'm going to block your effort to acquire registration to products I might sell in the future. So those are viable legal arguments against someone using the same trademark, even if it's for a non-competitive product. And it tends to apply only to the very well-known, famous, rich products.
Okay, I see. And what if I would have the same name, but like this part of it? Let's say, there's this name, it's a very unique name, it's not common. It's called Cure Work. And then the rest of the words are called like integrated medicine or stuff like that, and I just want to use the first word of it. I don't want to use the rest of it. Would that be also copyright infringement? What would be the case?
Potentially trademark infringement. And the thing is to keep in mind is that the trademark office or the courts are going to focus on what is distinctive about the mark. And added on generic terms are not the distinctive part. So, again, if I were Apple Computer and, back when the Beatles had Apple Music, well, the fact that one was computer and one was music was not going to help out either company. Like that gets disregarded. They would focus on the fact that they're both Apple, and that's going to be the problem. So, then you get into a deeper analysis of, well, Apple Music is a music studio releasing albums, and Apple Computers is a computer company. So, consumers can draw a distinction between the two. But it was never going to matter that one called themselves Apple Computers and one called themselves Apple Music.
All right. Thank you so much. Appreciate it.
Mm-hmm.
Any other thoughts for folks?
I've got a question. If like I've been running under Alaska's Best Shellfish for 10 years. And a couple of years ago, so of course, when you Google, I come up first.
Mm-hmm.
So 2 years ago, somebody, they couldn't get that. And so they went Alaska's Best Oysters. And it doesn't bother me one way or the other. But if could I, being I'm using geography, could I get a trademark? And I don't care if they're Alaska's Best Oysters, but if they would start running under Alaska's Best Shellfish, I wouldn't like it so much.
Well, a lot of that's veering into conversations you'd want to have under attorney-client privilege. So allow me just to offer a few like, high level thoughts here to have in mind for that conversation. The longer you're using what you've declared to be your trademark, longer in time adds strength to a trademark. If there are trademark rights to be had, the longer you're using it, that tends to favor you, that they become stronger with time. And in fact, there's a concept called acquired distinctiveness, where the trademark office acknowledges that, the threshold is usually is 5 years. Like, that's not the only way to show acquired distinctiveness, but 5 years or longer, then you can claim acquired distinctiveness. And that in many cases overcomes the fact that it's a descriptive trademark. Now you're attesting that you've been using it consistently during that time, exclusively to the best of your knowledge. And therefore, basically the idea is, the logic is, oh, the people know me. People know what they're getting when they go to this. Yeah, every single term of my brand is descriptive one way or another, but you put it together, and I've been using it for so long that now it's in people's heads, and therefore I have these rights, and someone else is infringing those rights. That's all an argument that can be made, but the duration of your use, at the end of the day, can only get you so far if you have to overcome the very descriptiveness or potentially genericness of a mark. Right, so it's an analysis to be done, but short of using something that is strictly generic, like if you told me your company's name was Seafood, I would feel more comfortable just telling you you're not going to be able to stop anyone else from using seafood to describe their seafood, and from that cliff you walk backwards down that scale we talked about before, from generic to fanciful, and what you want to be as closer to fanciful as you can get.
And on the other hand, if I applied and they said, no, you're just being descriptive, I would have a record that another company couldn't say, hey, you can't use that name. We've applied because I've already been denied, right?
Yeah, that's sort of like the compensation prize. Sorry you didn't win, but here's some turtle wax. What you get to take home is the opinion that it is available for use by virtue of being descriptive. So maybe you can't stop anyone else from using it. Transitively, it means you have arguments that no one can stop you from using it either.
Thank you.
Paul, I see your hand up.
Yes, sir. I had one more question, and yeah, just one after another started popping in my head. And you might actually answer this, but if you did, my apologies. Maybe I didn't catch it. This is for to what extent I can have basically my name. There's this specific trademark for that one particular word, and it is in a different kind of field. To what kind of extent I can have my own, the same word basically and trademark it.
You mean
for
like
different
Gucci?
purposes. Let's say this trademark that's already existing, it's about hair care products. My product is about like a marketplace where they give services with the non-traditional practices. Non-commercial practices.
I'm not sure I'm following. So let me repeat. You just tell me if I go astray here. But if you're aware of the trademark, a trademark being in use or owned by a hair care product, and the question is, can that same trademark, same word, the same phrase or whatever, be applied to? I'm sorry, was it
to the marketplace? Yeah,
marketplace services. Well, I mean, from an analysis standpoint, if you're able to box in what that other rights owner, what the other party does, and feel confident that there's a gap between what they're doing and what you're doing, and what we talked about just a second ago was, well, is this a famous brand? Does it reach that sort of level that they're a 10,000-pound gorilla? Then you might just be in trouble. But the the outcome might hinge on how wide the gap is between what they're doing and what you're doing. And from the way you just described it on its face, it sounds like, yeah, I would just spitball and say, well, those sound pretty different to me. Sometimes you're surprised. I'm constantly surprised though by what companies will blur and say, well, yeah, we're a hair care company, but we also provide financial advice. My catch-all evergreen advice is don't take it for granted. But as a matter of principle, yes, if you have a big enough gap between what you're doing and what they're doing, then you've knocked out one of the likelihood of confusion elements.
Okay, cool. Awesome. Thank you, John.
It's a dessert topping and a floor wax. So any other thoughts? Cool. So thank you so very much for doing this, John. I think it was very helpful and useful. We will be cleaning the ends of this up a little bit and then putting it up on the YouTube channel. We have a pitch deconstruction workshop for people that are practicing their pitches and trying to go next Tuesday. I always recommend to people that are doing any kind of startup that they should practice pitching just to get clarity on their business, if not to do fundraising practice. But the act of standing up and doing a 1-minute pitch is something that tunes the mind to speaking clearly to what you want to do. We will also do stage expectations for milestones. And so as you grow your business, we're looking for you to achieve specific kinds of milestones at specific stages. And you would like to sort of align what you're working on with what the investors expect along your journey. And so Hall Martin from 10 Capital Network in Austin, Texas will be giving that one. So I encourage you to sign up early to the workshop so that we can keep track of who's doing what. And again, the first Transatlantic Angel Conference demo day is on July 7th. So if you want to see how the end of our program works, that'll be an example.